So, in the article 21, we were I talked about the general aspects of 21 in another video. Now, in this particular video, I would like to talk about right to die with dignity. Right to die with dignity. See, in fact, this is all part of liberty. We have right to life under Article 21. Now, another question is there any right to die? In fact, this question, Supreme Court right from the beginning, the position by the Supreme Court was that there is right to life, but no right to die. This was the position by the Supreme Court. But in 1994, in fact, there was a case where Supreme Court in P. Ratnam versus Union of India, in P. Ratnam versus Union of India case, in 1990s, Supreme Court, a two-judge bench said that there is right to die, and in fact even said that Section 309 IPC, Section 309 IPC, which is the punishment for, where there is a punishment for attempting to commit suicide, 1 year imprisonment will be given. That was even declared illegal or unconstitutional by the Supreme Court, and Supreme Court even said that there is right to die. Supreme Court, that was the first time in 1994 it was said in P. Ratnam versus Union of India case. But subsequently, a larger bench, a 5-judge bench in 1996, in Gyan Kaur versus State of Punjab case, in Gyan Kaur case, Supreme Court overruled this judgment and declared that both assisted suicide, euthanasia, and even any suicide, okay, suicide or assisted suicide or even euthanasia, the mercy killing, euthanasia, all the three, any of them are unconstitutional or unlawful. So, that was in Gyan Kaur case, Supreme Court reversed earlier judgment and said that everything, even euthanasia, the mercy killing, who are in terminally ill patient also, it is unconstitutional. No assisted suicide, no suicide, I mean any suicide, anything, everything is unconstitutional. That is what Supreme Court said, that right to life is a natural right. Right to life is a natural right. But suicide is an unnatural termination of life. According to the Supreme Court, suicide is an unnatural termination of life. And it is against the spirit of Article 21. See, it is against the spirit of the natural right. Natural right is, you live as maximum as possible, but suicide is an unnatural term. And many a times, Supreme Court said that this, the people take the decision to commit suicide and all on a split second or other. If they have a second thought, they may not even do. It may be, and they may be emotionally, traumatized because of one or other reason, and they take this irrational decision in a spur of the moment. So, Supreme Court said that this cannot be clubbed under Article 21. So, in 1996 itself, Supreme Court declared that there is no right to die and there is no right to suicide, there is no euthanasia, there cannot be any mercy killing. So, Supreme Court is very clear. So, the Article 21 talks about life with dignity, and only aspects of life which make it more dignified could be read into this article. Only those provisions which can make the life more dignified, more meaningful, more powerful. That is what we can read into this article, and we cannot talk about anything which will curtail the life or terminate the life, which will cut short the life. That is what Supreme Court position in the Gyan-Kaur case in 1996. But subsequently, there was another case, this is called the Aruna Ramchandra Swambog case. Aruna Schwambog case. So, in the Aruna Schwambog case, so that was in 2011, Supreme Court said that, in fact, this was a situation where Supreme Court said that there can be passive euthanasia. For the first time, there can be, I will just come to that, there can be passive euthanasia. This Aruna Schwambog case is a very, it's a tragedy. In fact, she was a, she was a nurse in KEM hospital in Mumbai. In 1973, she was criminally assaulted by a ward boy in the basement of the hospital, and she went into coma. That was in 1973, and since then she was lying in the hospital, or she was in the hospital in a vegetative state. She could not regain her consciousness, and she continued to be in vegetative state, and her fellow nurses and all were taking care of her. KEM hospital was taking care of her, even though there were so many controversy about that, because once the hospital wanted to remove her from the hospital, the fellow nurses protested. So many things happened. Now, she was in the vegetative state since then, since 1973. But in 2011, one of her friends, on behalf of her, a person called, an advocate called Pinky Virani, okay, a person called Pinky Virani. She is an advocate, a social activist, a journalist, a writer. She filed a writ petition in the Supreme Court, claiming that she has enough of suffering, and the right to life include right to die also, and her freedom is not there. So she should be, there should be an euthanasia, or rather mercy killing should be there, and so that she can be relieved of the pain and other things. But Supreme Court said that regarding the death of an individual, who can take the decision? This could not be solely left to the discretion of the patient's relatives or the next friend or immediate friend like Pinky Virani. Supreme Court said that this cannot be decided by near and dear ones alone. If the same person cannot take a decision, it has to be decided by the state. Supreme Court said we cannot decide just, or you cannot force, and Supreme Court ordered against mercy killing. Subsequently, after a couple of years, our Aruna Schwambog died, not through this mercy killing or anything. She died, I think, in 2014. But in 11, this case was there, and Supreme Court said that there is no right to die there also, but there can be passive euthanasia in extreme circumstances, and Supreme Court said that there can be passive euthanasia, but it will be monitored under the court monitoring. A court monitored committee should be there. They can decide on whether there is a passive euthanasia should be there for a person or not. So, in the Aruna Schwambog case in 2011, Supreme Court talked about passive euthanasia, not active. So, what is the difference between passive euthanasia and active euthanasia? The difference is, is that in active euthanasia, something is done to end the patient's life. In active euthanasia, something is done to end the patient's life. To end the patient's life. So, that is active euthanasia. Then when it comes to passive euthanasia, then here something is not done that would have preserved the patient's life. So, in passive euthanasia, we are saying that something is not done that would have preserved the patient's life. So, say for example, the ventilator, if a patient is not kept on ventilator, something is not done to preserve the life. So, that is passive euthanasia. So, if the ventilator is switched off, something is not done, so that means additional air or the oxygen is not given to the body, and according because of that patient dies. So, that is, so passive euthanasia is permitted, something is not done that would have preserved the patient's life, that is passive. Active is something is done to end the patient's life, that is where injecting a poison or injecting some medicine which will stop the it's not medicine anymore, then it may be poison, injecting a poison or anything, then it becomes active. So, Supreme Court in 2011 distinguished between active euthanasia and passive euthanasia. That is what Supreme Court said. But subsequently in 2018, in 2018, in Common Cause versus Union of India, Common Cause versus Union of India, Supreme Court modified this, reviewed it and said that right to die with dignity is a fundamental right. So, in 2018, in the case Common Cause versus Union of India, Supreme Court declared that right to die with dignity is a fundamental right. Right to die with dignity is a fundamental right. So, right to life and liberty as envisaged in Article 21 is meaningless unless it encompasses within its sphere individual dignity. So, in this Common Cause versus Union of India, Supreme Court talked about individual dignity, and according to Supreme Court under Article 21, this right to die with dignity is a fundamental right. So, now, so that is where Supreme Court has moved one step ahead in 2018. So, now coming to this 2018 judgment, and in the process Supreme Court has very clearly saying that there can be a mechanism of passive. So, this passive euthanasia is been further magnified in the in the Aruna Schoenberg case in 2011. Supreme Court said in extreme circumstances, in rarest of the rare circumstances, under a high court judge monitored committees monitoring, a person can be administered, or a passive euthanasia can be there, Supreme Court said at that time. But in 2018, Supreme Court made it more clear and said that right to die with dignity is a fundamental right. And Supreme Court said that there is also a concept of living will, and under this judgment Supreme Court said that there can be a living will, which was denied or which was opposed by the center in the 2011 judgment. Okay. So, Supreme Court said that there can be living will by terminally ill patients. So, what is this living will? And but it should be guidelines. The Supreme Court also issued guidelines for living will. Supreme Court issued guidelines for living will. Now, what is this living will all about? It is a person's right to issue advance directive. A person's right to issue advance directives on the course of his treatment, directives on the course of his or her treatment. That means a person who is in a critical condition, he can give an advance directive regarding what should be the course of action if so and so thing happen, whether I should be allowed, I should be put into ventilator or not, all those things, the living will. So, but the problem is, if a situation arises, including now in the advance, a person's right to issue advance directive on the course of his or her treatment, including withdrawal of life support, including withdrawal of life support, including withdrawal of life support, if a situation arises. That is what the meaning of this living will. But there is still no way a living will provision can be made foolproof, because you have given the will, but who will do? Whether the situation has arose where the life support should have been withdrawn or not withdrawn, it is not very clear. So it may not be able to make it foolproof that easily. But Supreme Court gave guidelines, include Supreme Court in this common cause judgment has given guidelines which include who can execute the will, the living will, and under what conditions that the medical board endorse passive euthanasia. Supreme Court gave the guidelines regarding who can execute and under what conditions the medical board endorse passive euthanasia. The court also said that the guidelines and directives shall remain in force till a legislation is brought to deal with the situation. So, the Supreme Court guidelines will be in force till the Parliament passes a new law regarding this. So, this this living will as well as the judgment is because of that NGO called Common Cause. Common Cause filed this case. In fact, the case was in right from 2005 and finally the judgment came in 2018. So, in the living will you have a right to refuse artificial life support, and Supreme Court accepted this, but there is a guideline given, there is a procedure given, a medical board is to be created and it is to be monitored by a High Court judge. All these things are given, and in this judgment Justice Chandrachud, he is a very he is considered one of the most liberal judges and one of the highly learned judge, and also he is the son of a previous Supreme Court judge, okay, Y.V. Chandrachud. Now this D.Y. Chandrachud, he is a very, very famous liberal, a gem of a character. He said dying is a part of the process of living. In fact, Chandrachud in this judgment, Justice Chandrachud in this judgment said dying is a part of the process of living, part of the process of living. Because every day, every moment, we are dying also, because when our life is advancing, so naturally every moment we are losing one moment of the extra life which we have, the life which we have. So that is why he said, life cannot be disconnected with death. Dying is a part of the process of living, and the Supreme Court held that the right to die in peace could not be separated from right to life. So right to die in peace, right to die in peace cannot be separated from the right to life under Article 21 of the Constitution. So that is what this concept of living will, and Supreme Court said that you have a right to die in peace and in dignity. It's coming under Article 21, but Supreme Court said that active euthanasia is different, and Supreme Court is not permitting active euthanasia in India. So euthanasia is regarded as the only viable option when all life care interventions fall short of ensuring a better life for terminally ill patients. So that is the concept, the mercy killing which we are talking about. So that is what the Supreme Court has said that. So, but the problem, the final conclusion or the problem, the issues. What are the issues facing? One, there is a risk of misuse. There is a risk of misusing such a provision, especially because in India there is no social security network. The old parents are critically dependent on their children or someone who is to take care of them, and many a times the relationship at that stage, at old age, the relationship between the parents and their children may not be that smooth, and there is everybody is looking for taking over the property, the house. All these issues are there. So, there is always a chance of misuse if there is a living will and all. We cannot be ignoring this, that number one, because there is no social security network in India. Okay, social security in India, the way which is there in the outside world, I mean in the Western world, where after retirement the state will take care of you. You have a right to get a old age home, and your needs are taken care in the old age home automatically. No such situation in Indian scenario. So, this is a big problem. So, the chance of misuse is very, very high. And number three, many a times we in pain, people may talk about, people may demand death. They may demand ending life. But that is only because of lack of pain management or lack of palliative care. See, palliative care means the pain management and also patients who are terminally ill. Why they say that I want to die, or because of the unbearable pain of the disease. If you can reduce the pain, they will be more than happy to continue their life till this terminally ill patients reach their natural end. So, if in India, what is more required is more palliative care, more support to such patients, more even mental health. When you are down because of one or other disease, and if if there is proper counseling, lack of proper counseling, lack of proper mental health care. So, all these things are unnecessarily leading to pain and suffering of the people. So, we need more palliative care centers in India. We need for more counseling, more mental health care, so that we can counsel these people. Their pain, definitely, if somebody is there to talk and if they are able to communicate, definitely this demand and all will come down dramatically. So, we need palliative care, we need, and most importantly, the fourth point I would like to always insist is, once life once taken away cannot be given back. We will not be able to give it back. So, we should try to preserve this life as maximum as possible, give all support. But in this euthanasia and all, we are now, if you are taking away, there are so many cases where people in coma have suddenly come back to life. I was reading an article in this case, and I was found that a person, an officer, a fire officer, a fire department officer in US, in a rescue mission, he went into coma because of an accident there. He went into coma, and he was in coma for 20 years. But his wife and children did not allow his ventilator to be taken away. He was in coma. He was in a vegetative state. But suddenly, after 20 years, he woke up. There are so many instances where, I am not saying it's a common thing, but there are, and he has continued his life. So, there are many instances where people in such last stage, suddenly they got revived because of one or other reason. We never know. So, we should try to preserve the life as maximum as possible. And not only in India, the chance of misuse is very high, even globally, because of this chance of misuse. And no doctor can certainly 100% guaranteed say that this man will never revive. If somebody is in a coma state, there is always a possibility that a person can be revived. So, no doctor can certify and 100% guaranteed declare that he will never revive. So, once we take away the life, we will not be able to give it back. So, that is why we should, then in globally if you look, in Netherlands was the first country to legalize euthanasia in 2002, Netherlands. In 2002. And it has been found that even in such countries where the advanced medical system is there, healthcare system is there, old age care centers are there, palliative care is there, even there in Netherlands, like country, when analysis was made, now there is a temptation by doctors and even the relatives of the patients to say that, okay, since this is legal, let us go ahead with this. So, say medical termination of young children, or rather the fetus, again slightest of the pretext that there is a problem in the child, they are going for abortion or compulsory termination of that life. So, this can lead to more killing. I mean, it may be a small minor case, even then the parent, the doctors, everybody is prescribing, because there is a temptation to say that this is legal now, you can finish off. Euthanasia can be given, mercy killing can be there. So, my personal feeling is this should not be encouraged. The rarest of the rare, as Supreme Court has said, that it should be only in the rare scenario we should be, through a court monitored committee, medical board should be there. A High Court judge should be there on the panel to finally take a decision, because if you allow the relatives or children of the old parents to decide, there will be a temptation to finish off them because of the property issue, because of the house issue. So many things are involved. So, this can be very, very dangerous. That is why even the developed countries, very few countries have started this or permitted euthanasia. Belgium has done, first Netherlands, then Belgium has done. A couple of states in United States, US also have given this permission, but most of the countries are restraining themselves from giving this euthanasia concept. Even assisted suicide or assisted termination of this life, because there is always a chance of misuse, and there is once the life taken away, we cannot give it back. So, right now the situation in India is 94, till 94 the situation is there is no right to suicide or right to euthanasia or assisted suicide. 94 Supreme Court said that there is right to die. In 96, Supreme Court reversed it by saying that there is no right to die, because this cannot be, right to die is not compatible with right to life in Article 21. 2011, Supreme Court in the Aruna case, Supreme Court said that there can be passive euthanasia in rarest of rare cases under a medical board and all. But in 2018, Supreme Court made it more clear, there is right to die with dignity under Article 21, but then there can be a living will, and what living will can be executed only by a medical board, and the guidelines for execution is also given by the Supreme Court, and a High Court judge will be a party to that execution. So, that is the situation about right to die with dignity under Article 21.